The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program 915, coming to you on Monday the 1st of October 2018. On this program, I will speak to you on the topic Procedural Safeguards in Death Penalty Cases Pt2. But before going into the topic, a few preliminary comments. Sadly, very sadly, yesterday was a tragic day in the history of the spiritual Baptist faith. Because yesterday we lost a Reverend Mother and we lost an Archbishop in a vehicular accident. We have lost previous archbishops, but in all previous cases, the individuals were ill and ailing for some time, were on their deathbeds, and eventually passed away. But yesterday, it was not a case of a deathbed illness. It was a case where most of us were in church yesterday when we got the tragic news that our Archbishop and one of our Reverend Mothers had died in a motor accident. By now, the whole nation would know that it occurred at Garden Yard, North Leeward. And our Archbishop Frank Simon and Reverend Mother Labbett Young, both of whom presided at the funeral service of Reverend Mother Cupid just a week previously. Both died in that accident. But we have to thank the Lord for sparing the lives of the other two passengers in the vehicle. The driver, Brother Ezron Pompey, and his other passenger, Sister Philomena Tittle, our Archdiocesan Recording Secretary. The Lord has been good to both of them, particularly to Sister Tittle, because when I spoke to her by telephone today, she informed me that she was expecting to be discharged sometime this afternoon, because she had suffered no broken bones, but Brother Pompey will be there for quite some time, apparently. As Chancellor of the Spiritual Baptist Archdiocese, on behalf of the Archdiocese, I extend condolences to all of the relatives, both natural and spiritual, of our two deceased brethren. And according to our Constitution, the person who is now in charge following the sudden death of the Archbishop would be the senior bishop, because we have a hierarchy clearly defined: Archbishop number 1, Senior Bishop number 2. So His Lordship, the Most Reverend Melford Pompey, would now be acting as Archbishop until such time as the Council takes a decision ratified by Synod to fill the vacancy. The date of the funeral or dates have not been released as yet, and I will keep you advised. Today in St. Vincent and the Grenadines has been observed as the National Day of Prayer. And once again, we remind ourselves that we should be praying without ceasing. So notwithstanding today has been the National Day of Prayer, every day should be a day of prayer, but we thank the authorities and the churches for organizing a special day today, the 1st of October, as the National Day of Prayer. Excuse me. I apologize that I couldn't be with you last week, Monday, by reason of not having been feeling well enough to come into the program. My voice has practically gone because of a cold, but hopefully you can hear me tonight. Last week I should have done part 2 of the procedural safeguards in death penalty cases, but we repeated part 1 last week, and it is my pleasure and privilege to bring you part 2 of that program on this evening's program of The Law and You. The central thesis of this presentation is that whatever may be the position in other countries, here in St. Vincent and the Grenadines, it is practically impossible for somebody to end up on the gallows as an innocent person or by error. As you hear in other countries every now and then, in the United States of America, you hear of somebody who has been wrongly convicted and has been languishing in prison for a long time, or somebody who had been wrongly executed, and the real murderer in respect of that crime has come forward, or new evidence has discovered that the executed person could not have been the offender. That is almost impossible in our criminal justice system here in St. Vincent and the Grenadines by reason of the number of safeguards standing in the way of a potentially wrongful conviction and execution. Because I'll go on to show you in this part that even though a conviction for whatever reason might have been a little wrongful, it would be very difficult for that wrongful conviction to lead to somebody getting up on the gallows, because there are safeguards after the verdict has been pronounced. So on part 1, I dealt with the first 7 safeguards, and I'll just tip them off. First of all, the preliminary inquiry, by which a magistrate sifts the evidence and makes a ruling that the evidence led by the prosecution is enough to put the person on trial for the offense of murder. Safeguard number 2 is the fact that an accused person, a person accused of murder, must have legal representation at his or her trial. Safeguard number 3, that trial has to be a jury trial. Safeguard number 4, the presumption of innocence. The law presumes, according to the Constitution, that an accused person is presumed to be innocent until his or her guilt has been established, or until he or she has pleaded guilty. Safeguard number 5, I bundled together the rules of evidence, which are exclusionary and tend to prevent wrongfully obtained evidence from getting before the jury. Safeguard number 6, the special rules concerning confession statements, where they have to be deemed to be voluntary before they could be admitted in evidence against an accused person. And safeguard number 7, the summing up, the judge's summing up. Now, these are matters occurring before the verdict. We now move on to safeguard number 8. And that lies in the development over the last few years that following a guilty verdict by the jury, judges no longer have the right to pronounce the death sentence. Long ago, if the jury brought in a verdict of guilty of murder, the judge will put on a black cap on his or her head and pronounce the sentence of death, because that is what the law required in those days. But there has been a development in the law in the Caribbean whereby if the jury brings in a verdict of guilty of murder, the judge cannot impose the death sentence automatically. The judge has to have a second hearing to determine whether or not the death penalty would be appropriate. So that is called a sentencing hearing. I call that safeguard number 8. At that sentencing hearing, the judge will hear further evidence, and the judge will then decide whether it will be appropriate to impose a sentence of death or some other sentence. And in coming to that conclusion, the judge has to be guided by one cardinal rule established by the Privy Council, that unless the circumstances of the crime indicate that that crime was one of the worst, according to the Privy Council, the death sentence would not be applied. What is the worst of the worst? Well, nobody knows for sure, but we know what it is not. In St. Lucia, some men went into a Roman Catholic church, threw an inflammatory liquid on a nun and set her alight. She was killed by that process. And it was held by all the courts that that was not the worst of the worst. It was bad, yes, but not the worst of the worst. In St. Vincent and the Grenadines, a young child was strung up, molested and killed. The Privy Council said that was not the worst of the worst, and therefore the person who was convicted of that could not be sentenced to be hanged. In St. Vincent, an assailant cut off the head of, the fellow, who happened to be the brother of one of our bishops, Bishop Selwyn Brown's brother, in the mountains in the Mesopotamia Valley, cut his head off, mutilated the body. That was not regarded as the worst of the worst. So I don't really know what you have to do to be deemed by a judge to have committed a crime in circumstances where that crime, the crime of murder, could be said to be the worst of the worst. So I am telling you that to tell you that the judge's hands are tied. And the law says, the procedure says that the judge cannot impose the sentence of death in those circumstances. He has to impose the sentence of life imprisonment or imprisonment for X number of years. So those sentencing procedures constitute hurdle number 8. Now, let us assume you pass that stage. Safeguard number 9 lies in the right of appeal. Everybody who is convicted of murder has the right to appeal first to the, in St. Vincent and Grenadines. He has the right to appeal first to the Eastern Caribbean Supreme Court and then to the Privy Council, where again, if he is penniless, it doesn't matter. There are lawyers who take it upon themselves as their bounden duty to plead the cases of anybody sentenced to death. Not only that, procedurally, a person convicted of murder and sentenced to death has the right to appeal to human rights bodies outside of St. Vincent and the Grenadines. And execution cannot be carried out until those bodies have deliberated. In fact, there are other procedural safeguards, but I do not classify them separately. In that, the Privy Council has established that if somebody has been on death row for 5 years, you can't hang them after 5 years, no matter what the circumstances. And there were later cases that said that the period could even be less than 5 years. So I'm showing you how difficult it is to get somebody in the gallows, on top of the gallows, who is innocent, or of whom it can be said there was a miscarriage of justice. Now, the next procedural safeguards, I lump them together, have to do with the Mercy Committee. Even after one has gone through all of that, all the appeals, you come to safeguard, the major safeguard, which consists of several minor safeguards within the topic, the Mercy Committee. Our Constitution, like many other constitutions, says that there shall be a committee on the prerogative of mercy, generally called the Mercy Committee. And before anybody could be hanged, the case has to go before the Mercy Committee. They don't have to even ask for a Mercy Committee hearing. Automatically, before the sentence of death can be carried out, the Mercy Committee must deliberate on the matter. And only if the Mercy Committee says, okay, go ahead and hang, can somebody be hanged in this country. What is the Mercy Committee and what are its powers? Well, the Constitution says the Mercy Committee shall consist of 1, a person designated by the Prime Minister as chairman. And in my experience, since we got our Constitution, the Prime Ministers themselves have been the chairman of the Mercy Committee. 2, the Attorney General. And I was Attorney General for 8.5 years. I sat in the Mercy Committee for 8.5 years, so I know what I'm speaking about. 3, another Minister of Government designated by the Prime Minister. And 2 or 3 more persons chosen by the Prime Minister and appointed by the Governor General on the advice of the Prime Minister, one of whom must be a minister of religion, and one of whom must be a registered medical doctor. And in my experience, the Mercy Committee has been the Prime Minister, the Attorney General, one other Minister of Government, a Minister of Religion, and a doctor, a medical doctor. So the Mercy Committees I have sat on have consisted of 5 persons. Secondly, in my time, the Prime Minister Mitchell announced a policy that decisions of the Mercy Committee will have to be unanimous if it involved carrying out the death sentence. So unless all 5 members of the Mercy Committee say, yes, go ahead and hang that person, the person will not be hanged in St. Vincent and Grenadines. Therefore, the circumstances have to be such that all 5 persons, including a minister of religion, and a doctor, and you know doctors take the Hippocratic oath against the taking of life, well, you have to persuade a doctor that this fellow should hang. Otherwise, whoever doctor you get on the Mercy Committee will say, no, don't hang him. And finally, the final safeguard is this. The Mercy Committee, according to our Constitution, must consider a confidential report from the trial judge before coming to their conclusion. Many people don't know that. But a judge in a murder case, quite apart from summing up to the jury, has the right, in fact the duty, to write a confidential report which he passes to the Mercy Committee. Nobody gets to see it except the members of the Mercy Committee. And when they're finished, those documents are destroyed. So nobody gets to know what the judge had said. Therefore, if a judge presides over a trial, regardless of what verdict the jury brings in, bring in a guilty verdict, if the judge, for whatever reason, feels uneasy about that verdict, he can't interfere with the jury verdict of guilty, but he will simply write in his report to the Mercy Committee words like, notwithstanding the jury verdict, I have my misgivings in this case, and coded language of that kind. And the Mercy Committee will say, look, the judge is saying this fellow should not be hanged, he will not be hanged. On the other hand, if the judge sees no redeeming feature, is totally satisfied that the person was rightly convicted and that he deserves the death sentence, the judge will say words like, having presided over the trial, I see no reason why the law should not take its course. The judge is saying, look, go ahead and do what you want. Now, these taken together are extremely important safeguards, so that if at any stage of the trial there's any reason to believe that, look, it might not have been that person who did the act, or whatever else may show some little doubt on the guilty verdict, somewhere along the line that will be picked up either on appeal by the judge in his confidential report or by the Mercy Committee itself. It is only when all the members of the Mercy Committee are totally satisfied that there is no redeeming feature of the case, that the person really deserves to be hanged, there's no other reasonable recourse. It's only when all of that takes place that a person could end up on the gallows in this country in the execution of a sentence of death pronounced by the judge after the sentencing hearing, missed on appeal before the Court of Appeal, the Privy Council, and the other international bodies, missed by the Mercy Committee, It is simply not humanly possible for that to happen in St. Vincent and Grenadines. You don't have those totality of safeguards in some other countries. I'm not saying that if I were a citizen of some other country that I may not be against the death penalty in that country. But where you come to St. Vincent and the Grenadines, my brothers and sisters, there is nobody who could bring up any credible argument that it is possible to hang an innocent person here. You will have to have a conspiracy of the inquiring magistrate, of the 10 jurors at very least who have to find him guilty, of the judge, of the Court of Appeal, of the Privy Council. All of them will have to conspire to cover up a wrong. Then the members of the Mercy Committee will have to conspire to cover up a wrong. It can't happen. So whatever objection one may conscientiously have against the death penalty, don't raise as an argument the possibility of carrying out the death penalty on an innocent person in this country. It simply cannot happen. I know there are people with strong views against the carrying out of the death penalty. I've had dear friends from way back when who are of the opposite view. Not this George. I feel and I'm satisfied that in the context of St. Vincent and Grenadines, the death penalty is a deterrence. And now that everybody knows that it has been practically abolished by the courts, we don't have to wonder about the willingness of persons to take human life in a wanton manner, knowing that their life is not and cannot be placed on the line. I want to thank Dr. George Frederick and the other members of Encounter for the kind remarks they made and for the stand which they have taken on that issue. I hope it is a topic which we reopen in this country, because when we shriek about the explosion in crime, let us not forget that in some ways we are complicit in that we have said we would not impose the ultimate penalty. The would-be criminals have heard that loud and clear, and they have acted accordingly. I'm satisfied the death penalty is a deterrent, and as long as we have put it aside, we have to pay the consequence of that decision. I remember when I was little, a fellow would say, boy, if they wouldn't hang me here, I would have done so and so to you. You don't hear that again. The absence of hanging has rendered the would-be murderers immune from any sense of fear. They don't care. They don't care. These are things which society has. Follow other countries and be as liberal and lenient and laissez-faire as they are, and we will just go along that path as well. But for the innocent person, there is nothing to fear. If you're truly innocent, somewhere along the line your innocence would be established. Well, that is all from this program of The Law and You, program number 915. Speaking as I am tonight with an extremely heavy heart. But such is life. The good Lord knows best. He gives and He takes away. Do have a pleasant week, brothers and sisters, ladies and gentlemen, boys and girls, and may the good Lord continue to bless us all.
The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.